Great. So everybody's here. A couple of disclaimers that I always like to start every presentation out with. We're not giving legal advice here. This is a legal training program. You get your legal advice from your in-house counsel. If you're a large agency, you typically have in-house counsel, either that or your prosecutor's office or your city or county attorney's office. Legal training is what we provide today, not legal advice. And also, be mindful that your agency's policies can be more restrictive than the law. A lot of agencies do have, in some regards, different policies that are slightly more restrictive than the law is. So just understand that we're talking about what the law is, particularly the federal constitutional law, and your agency, certainly it is within their prerogative to be more restrictive in that regard. So make sure you consult your policy as well. All right. Why this stuff is serious? And I do this with all my presentations. I just got done for the last 6 days. I was teaching a recruit class here in southeastern Virginia, and I can't emphasize enough to them why what we're talking about here, not just probable cause, but all of these search and seizure topics, why it's serious business. I like to tell particularly young officers, what you've signed up for, this law enforcement profession. It's not folding sweaters at the Gap, okay, where when you make a mistake there, okay, people don't get hurt. Consequences aren't that serious. If I fold a sweater incorrectly at the Gap, what do? I just unfold it, refold it, and I move on to the next one. And that's it. This is the consequences of being wrong here. Can be severe. People can get hurt. People's liberty is at stake. We've got evidentiary issues to consider for ourselves. There's civil liability that could attach, and in some cases, criminal liability for being wrong. So we want to make sure that we comprehend or we appreciate the seriousness of this stuff that we're talking about here. This search and seizure constitutional law stuff today. Probable cause. We're going to dive deep into probable cause. I find this is probably one of the hardest topics to teach for me, particularly for recruit officers, because they have no basis for knowledge. When these notions of probable cause and reasonable suspicion, they tend to be somewhat abstract. But even with veteran officers, it can be very difficult in determining, well, what exactly is probable cause? What is reasonable suspicion? So hopefully today, at the end of this hour, we can maybe have a better idea of what it means to say that you have probable cause. So just a couple of statements in general about probable cause. First and foremost, probable cause by itself is never enough to conduct a search or a seizure. So just having probable cause to believe there are narcotics inside of a home is not enough to walk inside and seize those narcotics. You always need probable cause as a prerequisite, and then you need something else. You either need a warrant or an exception to the warrant requirement. Blue to Gold has a really good and easy to remember acronym, CREW. Remember, you always need with probable cause. You would either need consent, which obviously I don't need probable cause to ask for consent. But if I have probable cause, then I'm going to need either a recognized exception to the warrant requirement, such as exigent circumstances. If we're talking about cars, we've got the automobile exception, or if none of those exceptions exist, then we need a warrant. Okay. All right. So probable cause. What is it? This is a very famous quote. You'll see it in many cases that deal with probable cause. This quote is recited. It's a flexible term. It's not this rigid, technical term. Like, for example, preponderance of the evidence. I'll bring that term up again a little bit later on. That's a more flexible. That's a more rigid technical term. This is based upon common sense. Inferences from facts, from observable facts. It doesn't have to show, we're not required to show that we have to be more likely true than false. We'll talk a little bit more about that a little bit later. Like I said, it's not a technical standard. It's designed to be flexible. It's designed to accommodate the needs of law enforcement out in the field, but also to respect the privacy interests and the liberty interests that are protected by the Fourth Amendment. So it's kind of a balancing of those two interests. It doesn't require certainty. It just requires enough facts and circumstances to have a good reason to believe that whatever the allegation is true is true. We don't have to be absolutely certain. One of the places that I see this come up most frequently is this. Well, we have to know this to be true. When we talk about using an arrest warrant to enter someone's home to make an arrest, I think all of us are well aware that if you have an arrest warrant, a reason to believe the person is inside their home, inside of a home, and reason to believe the home they're inside of is their home, then the warrant carries with it the authority to go and look for them. Many officers seem to be under the impression that if we don't know he's inside for certain, we're not allowed to go inside and get him, or we don't know that he lives there. That's absolutely not true. When it comes to the Fourth Amendment, absolute certainty is very rarely required for anything. Typically, probable cause is about as high as a standard that we're held to. Okay, so it doesn't require absolute certainty. Definitions of probable cause, there's a bunch of them floating around. They're all, they're probably all correct in some regard. This is one that I like to use. I don't focus a whole lot on what the actual definition of it is. I'm more interested in helping us conceptualize it. But here's a very common definition, and there's nothing wrong with it. Probable cause to arrest someone is facts and circumstances drawn from a reasonably trustworthy source. We'll talk a little bit more about that tonight. That would cause a reasonable person to believe this particular individual has committed a crime. So that's the definition for arrest. And then probable cause to search, very similar definition, just substitute a few words. Again, there's that reasonably trustworthy source that would cause a reasonable person to believe that evidence of a crime is located in a particular location. I don't find the definition to be very helpful. I think most officers would agree with that. That doesn't really tell me much about what does it mean to say that I have probable cause, and that's what we want to try and work on this evening. So what happens if my belief is ultimately disproven? This reasonable belief that I believe a particular person has committed a crime, or this reasonable belief to believe that there is evidence of a crime in a particular location. Well, probable cause accounts for that. By its very nature, probable cause leaves room for being wrong. It's just probable cause. It's not definite cause. It's just probable cause. There's room for mistake. In fact, I would contend there's probably a significant amount of room for mistake when it comes to probable cause, as long as those mistakes are reasonable. A reasonable person that's presented with those same exact facts could draw the same conclusion that you drew. That's if that's true, then you had probable cause, and just because something turned out to not be true doesn't somehow retroactively render your probable cause to be non-existent. This is a quote from Terry. I'm sorry. This is a quote from Illinois versus Warlow, which is it's a reasonable suspicion case, but there's some applicable elements of probable cause there. The court says, just because we've arrested someone on probable cause, later it turns out they're actually innocent, then it doesn't mean we didn't have probable cause in the first place. Sean asks a question here in the chat. It's a really good one. Is it a reasonable person or is it a reasonable officer in the same situation? The cases use both terms, and I just use the reasonable person terminology. But as we'll see here in a little bit, I'll give you a couple of cases that reference this. I think ultimately it boils down to a reasonable police officer's belief, because the Supreme Court and the lower courts routinely emphasize that the officer's training and experience is very relevant and very important in determining not just reasonable suspicion, but also probable cause. So, Sean, I think if you wanted to substitute reasonable police officer in that definition that I just gave you for either one of those, arrest or search, you would be correct. I think we're ultimately going to be talking about the same thing. Would a reasonable police officer find this to be suspicious or believe this person has committed a crime? So we'll have some cases that address that very good question in just a moment. Again, this is just summarizing what I just mentioned. Probable cause by its very nature, it leaves room for being wrong. And just because you're wrong doesn't mean that you didn't have probable cause, and the same is true of reasonable suspicion. In fact, reasonable suspicion gives more room for probable cause. Nathan, doesn't a jury evaluate probable cause? Well, it depends on what the issue is. Juries determine questions of law, and judges determine questions. I'm sorry, other way. Juries determine questions of fact. Judges, when a jury is involved, will determine the law. So, in a motion to suppress, okay, which is a pretrial motion, if the defense is trying to have evidence suppressed because we didn't have probable cause for the search, is the allegation, then that's a question of law, and a judge determines that. So we would put on our evidence in this pretrial motion, and the judge would determine as a matter of law whether probable cause existed. Now, a jury can make probable cause determinations. Say it's a civil suit. Say an officer is being sued for excessive force or an unlawful entry into a home. Then the existence of probable cause becomes a mixed question of law and fact. And where there's a question of law of fact, then the jury does weigh in on that. But this is where jury instructions would come into play. This is where the prosecutor, and if it's a case of a civil case, the defense attorney, the attorney representing the officer, would want to ensure that the jury is instructed what the correct standard is. This officer's actions have to be evaluated through a reasonable police officer in that situation. So it depends on whether we're talking about questions of law or questions of fact as to who gets to evaluate the PC determination. But in criminal cases, it's typically a question of law, and it's going to be the judge that is making that determination, not the jury. And just because I search a place and I don't find what I was looking for doesn't mean it was an unlawful search. Just because I arrest someone and they are ultimately either the prosecutor decides not to prosecute the case or a jury ultimately acquits the person doesn't mean the person was illegally arrested, and they don't have some false arrest claim against us. The existence of probable cause is an absolute defense to a false arrest claim. And this is an interesting case. It's a Supreme Court case. They arrested the wrong person in this Hill case. The officers, according to the court, were reasonable in their mistaking Hill for the guy they were arresting or looking for. Their belief that he was the guy they were looking for was reasonable under those circumstances. So even though they arrested the wrong person, doesn't mean that the arrest was unlawful, assuming our belief that this was the correct guy was who we were looking for. But this is why, particularly with warrants, the warrant has to describe with particularity who we're looking for. That's a Fourth Amendment requirement to try and avoid these kinds of situations. So even arresting the wrong person can be justified as long as the mistaken belief was reasonable. Speaking about mistakes, okay, so let's say I'm developing my probable cause to search or seize. What if part of my probable cause determination is based upon some mistake that I made about a particular fact or a particular factor? Let's see. This is a search warrant. Yeah, so we get a search. Trey says, well, we get a search warrant for a house because we believe they're selling narcotics out of the house, based upon some confidential informant buys of narcotics, and we get a warrant. We search the house, and they don't have any drugs in the house today. That doesn't mean the search was illegal. That just means on the day we chose to search the house, they happen to be out of their supply. The next day, maybe they're going to be restocked, and another search warrant could be issued then. But it doesn't mean that our search was unlawful. It just means our belief that they currently have drugs in their house was disproven based upon other factors. So let's talk about mistakes of fact, and then we'll talk about mistakes of law. So if my probable cause determination is based in part or in whole on some mistaken fact. This was an interesting case out of the DC circuit where the officer thought Williams, from his vantage point, he thought Williams wasn't wearing a seatbelt, which was a violation of the traffic law in Washington D.C. So he makes a traffic stop, and he ends up arresting Williams. I can't remember what he found, maybe narcotics inside the car or something about that. But turns out he actually was wearing his seatbelt. But from the officer's vantage point at the time, when he initiated the traffic stop, he reasonably believed that he was not wearing his seatbelt. And the DC Circuit upheld the stop, saying the officer did, in fact, have probable cause to make the stop, even though Williams was, in fact, wearing the seatbelt. The officer's mistaken belief was reasonable, given the vantage point that he looked at, the vantage point that he was using. Seth has a question in the chat. Can you talk about warrants and geographical locations? The Find My Phone app. Are you talking about whether that by itself is probable cause? If someone's Find My iPhone app indicates that a phone is in a particular residence? Is that what you're asking, Joe? If so, I think absolutely. I think that if that is a question, is someone's Find My Phone app indicating that the phone is inside of a particular residence or a particular place, is that probable cause to search that place? I think that the app that you're using is sufficiently reliable to constitute probable cause. Now, whether we need a warrant or not is going to depend on what that location is. If it's a home, we're almost certainly going to need a warrant unless there are exigent circumstances or we get consent to come inside. But that information from the app I imagine would almost certainly provide probable cause. Yeah, with Shane says he's used the location information from the app to do a knock and talk. Yeah, in most states, we don't need any reason to do a knock and talk. I've encountered a few states where you have to have at least reasonable suspicion to walk up to somebody's front door and engage in a knock and talk. With this, we certainly have it. I think the location information from the app, it gives you at least the reasonable suspicion you need. I think it gives you the probable cause. But yeah, we can go knock on the door and attempt to maybe get consent to come inside in a situation like that. So again, even if you were mistaken about a relevant fact and you base your probable cause determination on that, it can still be counted favorably towards your PC determination. What about a mistake of law? Now, this doesn't come up very frequently. The leading case on the Hine case, it's a reasonable suspicion case. But the principle is the same for probable cause. And I think we might have talked about this last week in our reasonable suspicion deep dive. But the officer here initiated a traffic stop on Mr. Hine's vehicle, and one of his brake lights or tail lights was out. And at that time, at the time that the officer made the stop, the code section that he was relying on regarding how many lights you have to have illuminated, it was somewhat ambiguous. It could be interpreted one of two ways, that if one light was out, that was a violation of the statute. Another way of reading it reasonably could be that only one of the lights had to be working. So he stops the vehicle for one of the lights being out, and I think he found drugs in the car. And ultimately, well, between the day of the stop and the day of the hearing on the motion to suppress, the North Carolina Supreme Court, I believe it was, the Court of Appeals or Supreme Court, had actually interpreted the statute, gave us what the statute means. They resolved the ambiguity, and turns out it was that only one of the lights had to be working. So the officer was in fact mistaken about what the law required regarding how many lights you have to have functioning. But the Supreme Court ultimately held the stop was lawful, even though the officer made a mistake of law as to what the law he was enforcing. He was mistaken as to what it required. The court said that was sufficient because it was a reasonable mistake. And that principle would be the same for probable cause, even though this is a reasonable suspicion case. Now, it isn't very often that we're going to be able to justify a mistake of law. Okay, so even though we've mistaken about what the law is, as long as it's a reasonable mistake, we can rely on it. But we need to be mindful of what Justice Kagan mentioned. We can't be willfully blind to the law. We can't, purposely not learn the law. We can't rely on erroneous training bulletins, policies that misinterpret the law. We're presumed to know what the law is. I mean, we are law enforcement officers. It's in our title. And we always tell citizens, ignorance isn't a defense to the law. Just because you didn't know what the speed limit was doesn't mean you're not required to adhere to it. And the same holds true for police officers. So I can't envision a lot of situations, particularly when it comes to probable cause, where we can rely on a reasonable mistake of law. But in some search cases, maybe we're searching for evidence of what we thought was a crime. It turns out that actually wasn't a crime. Then as long as it was reasonable to believe that was an offense, it could come into play. But I don't think it's going to come into play very often. We do have an obligation to be well versed in the law that we are enforcing. Let's Matthew has a question in the chat here. He says, while we're talking about these mistakes, are these things that protect the case, or does it protect liability as well? I'm assuming you need civil liability. Yeah, both. It can certainly protect the admissibility of the evidence in a criminal case. So if the exclusionary rule is being invoked, as long as we had probable cause, even though it was based upon a mistake, then it's not a violation of the Fourth Amendment. And if it's not a violation of the Fourth Amendment, then it can't be a basis for civil liability as well. So even though I was mistaken in the Hine case, perfect example, if I was mistaken as to whether the law required two lights to be work or three lights to be working, ultimately, if that mistake was reasonable, it's not a violation of the Fourth Amendment. And of course, these are different juries, or they're different courts that are going to determine this. But the standard, there's a lot more protection for us in civil cases than in criminal cases. There's very few exceptions to the exclusionary rule. But this notion of qualified immunity protects us in a lot of our civil cases, as long as a reasonable officer would believe that there was probable cause. That's usually going to suffice to protect you in a civil case, even if there was a violation of the Fourth Amendment. So either way, these mistakes cases that we're talking about would be applicable in both contexts: exclusionary rule and civil liability. Is it a subjective or objective standard? Definitely, we want to make sure we understand this. And I think most veteran officers know that probable cause is an objective standard. The existence of probable cause is objective. It doesn't matter whether the individual officer actually believed there was probable cause or not. What matters is, would a reasonable police officer in that position draw that same conclusion? And this is a good point the Supreme Court makes in the Beck case, that if probable cause was just a subjective standard, then there would be no protections from the under the Fourth Amendment. And as long as the officer thought there was probable cause, then the search would be lawful, and that would basically render the Fourth Amendment meaningless in that regard. It is absolutely an objective standard. Would a reasonable officer, given those same facts, draw that same conclusion? Yes or no? That's what we mean by an objective test, not a subjective test. Objective tests are fact-based, and conclusions drawn from those facts. Subjective tests involve inquiring into a particular person's state of mind, how someone feels about something. And it cuts both ways. I thought this was an interesting case. You don't see many cases like this, but this was a case where the officer didn't believe that he had probable cause. And the court ultimately said, well, even though this particular officer didn't feel like he had probable cause, the objective facts and circumstances indicate he actually did have probable cause. So normally we're trying to argue the opposite. We believed there was probable cause, therefore it was objectively reasonable to believe there was probable cause. Therefore, we should be our action should be condoned. In this case, the officer didn't think he had probable cause, but turns out he did. So the court actually saved the officer, I guess, if you want to think about it in this context. Like I said, remember, it's a legal question, so ultimately it's going to be a judge. The judge is going to be the determiner of the existence of probable cause, particularly in a criminal case where the exclusionary rule is in question. Let's talk about training experience. I mentioned this earlier, and this is where the reasonable police officer comes into play. Before we move on, Jean Ann says, in reference to Williams, once you've dispelled your PC for the stop, does this not say the stop is over? Yes. And the same thing with reasonable suspicion. Once we have confirmed that our suspicion or our belief is not true, then our legal basis for maintaining the seizure of the person should be over. But I will admit that there is case law that cuts both ways in the states. This is going to depend on which state you're in and what position your state high court has taken. The Supreme Court's never addressed this issue. And this normally comes up in reasonable suspicion context, but we certainly could apply it in the Williams case here. The guy we thought wasn't wearing a seatbelt, what in fact was. So we walk up to the car and we see he is wearing the seatbelt, and we have no objective reason to think he just put it on. I mean, that's kind of a harder one, but to show. But let's just say we have no reason to believe he didn't just put it on. He actually was wearing his seatbelt. The Fourth Amendment, I think, tells you that stop is over. My lawful basis for detaining that person has been dispelled. But there is case law in some states, and this is the minority position, but there are a significant number of states that take the position and say you can at least request the person's ID, or in fact, not just request, demand the person's ID just to confirm that they're licensed, they're allowed to drive the vehicle, and then send them on their way. So in other words, you can continue the detention for a brief period of time to confirm they're still licensed, and then send them on their way. I know Texas is one state that does take that position. Ohio, I'm almost positive, is another one. But then there are other states like Florida, I believe, is one that says no, the stop is over. Once you've dispelled the suspicion, you cannot detain them for one moment longer to do anything investigation related, including ask for their ID. But as Jean Ann mentions, what if I walk up there, I see he's wearing a seatbelt, but I see in plain view contraband or evidence of criminal activity, or I smell alcohol coming out of the vehicle, then you have new reasonable suspicion or perhaps new probable cause, depending on what you see. So a new detention or new basis for the detention exists. So you may continue to detain that person in that case. But absent those kinds of things, I think the correct position is this stop is over. You got to let that person go, absent something in plain view. Tyler tells us Illinois takes the affirmative position as well. I'm presuming he means the majority position where you got to let them go. I think that's correct. So very good question. Very good question, though. Training and experience as a basis for probable cause. We mentioned this earlier. It absolutely is required. Now, Terry obviously is a reasonable, well, it's what we now call reasonable suspicion. The term reasonable suspicion was never used in the majority opinion in Terry, but we now know that it means reasonable suspicion. That can be based on your training and experience, obviously, and the same goes for probable cause. This is a case out of Illinois, and here it is right here. This is the Illinois Court of Appeal telling us that probable cause is determined from the standpoint of the officer with his own specialized skill and knowledge, not just this average citizen. So the reasonable person can be thought of as a reasonable police officer, to answer a question from earlier. And I think that's the correct way to think of probable cause. If I'm allowed to use my training and experience to determine whether I've got enough to stop someone, to search them, to arrest them, then I certainly have to view it through the eyes of someone who has that same training and experience. Oh, okay, Tyler, I'm sorry. He says Illinois says you can continue the stop. People versus Cummins. Yep. So my mistake. So Illinois takes what is the minority position, which is that you can continue to stop to at least identify them. I think that's probably the limitation on what you're allowed to do. So Illinois will add them into the category with Texas and Ohio. No problem. That was my misunderstanding, not yours, Tyler. This is an important point. Okay, so yes, I'm allowed to use my training and experience, but it's incumbent upon me to articulate in my statement of probable cause, if it's an affidavit for a search warrant, or if I'm filling out an affidavit for an arrest warrant or a criminal complaint, whatever terminology or form you might use in your jurisdiction, we have to explain to the judicial official, the magistrate or the judge, how we drew that criminal inference based upon the facts that we saw from our training and experience. So it's not enough to just to say, based upon my training and experience, I believe there are narcotics inside this vehicle. We have to tell what that training experience is and how we were able to create a nexus between the facts and circumstances that we saw and this criminal conclusion. So these conclusory statements about how something you observe is consistent with your training experience as being indicative of criminal activity, that's not going to suffice. It's got to be articulated, just like with reasonable suspicion. Making such a statement isn't going to be very helpful at all. The judge has to be able to see where we're coming from, or the magistrate where we're coming from in that regard. And this is sometimes officers are led to believe, and I think magistrates and judges might help with us in this belief, might encourage this belief. Probable cause to get a search warrant for a house is the same probable cause you need to arrest someone. So probable cause for a search is not higher than it is for an arrest. Now, how much evidence we need to get to probable cause can vary depending on what it is we're trying to accomplish, and the seriousness of the offense, the degree in which we have to intrude upon the person's privacy or liberty. But at the end of the day, probable cause is probable cause. There's no higher standard that we use when we're talking about obtaining a search warrant for a house versus doing a warrantless search of a car. Probable cause is probable cause. This is not a reasonable suspicion class, but I think there's such a close relationship between the two. I just want to make a couple of points. Especially when I teach probable cause to recruits, I think it just makes more sense. And even for veteran officers, if you just think of reasonable suspicion as probable cause light, it's just little probable cause. So if we grasp what probable cause is, or we have a good understanding what probable cause is, then you can figure out what reasonable suspicion is. It's just less. It's just less of it. It's just less facts, less circumstances. It can come from less reliable information. The information still has to be somewhat reliable, but it can just be less reliable. And that's because reasonable suspicion typically allows you to only permit a lesser intrusion, a Terry stop versus a full-blown arrest or a frisk, as opposed to a full search. So reasonable suspicion effectively is just little probable cause. If you want another kind of analogy, probable cause is Budweiser. Reasonable suspicion, just Bud Light. Okay. It's the same thing. It's just less of it. It's just a diluted form of it. There really isn't any functional difference between the two. If that doesn't work for you, probable cause, reasonable suspicion. It's just little probable cause. That's really all it is. And one activity that I do this, and I don't know, I try to be cautious about the limitations on how valuable this is, but sometimes I'm sorry, here it is. Probable cause it's effectively just a little bit of reasonable suspicion is just probable cause to detain someone, or it's probable cause to frisk them. But we use a different term, reasonable suspicion, so that we can distinguish between the two of them easily when we're talking about it. At the end of the day, we're talking about the same thing. Because another way to think about it, or another important thing, is that the term probable cause is mentioned in the Fourth Amendment, but the term reasonable suspicion isn't. That's because reasonable suspicion is probable cause. It's just less of it. So an activity, I mentioned this, lesser quality of information, less reliable. An activity that I definitely do this with recruit classes. I don't do it so much with veteran officers because I think it's of less value, but it still has some value. So we'll talk about it in a minute, for just a moment. Using a continuum, like drawing what I call a factual justification continuum. Sometimes this can help try and conceptualize probable cause and reasonable suspicion. If we can put PC and RS on this continuum where we have other recognized legal standards, it can kind of help us picture or envision, like, how much information you have to have probable cause. So we use this continuum. Now, I do this exercise for two reasons. One, because there's some educational value, but I also love the word continuum. I'm a big word person. I just like unique words. Continuum is a very unique word in the English language. It is one of only a few words that have two U's in succession in it. There's only one other commonly used word in the English language that has two U's, and most of you know what it is. It's vacuum. Where is it? Vacuum. Now, I did this exercise a few years ago with some recruits, and I made this statement right here. And a recruit comes up to me on one of the breaks and says, you are incorrect. Well, that's one way to get my attention, is to tell me that I'm incorrect. So you now have my attention. What am I incorrect about? He says, there's another word that is used in the English language that has two U's. In fact, it has two sets of two U's in it. And I said, well, please tell me what word that is. And he said it's moo. All right. Now, does anyone know what a moo is? Not moo, not Moo, Amanda, but yes, it sounds like it. Yes. So a moo. If anybody's ever seen the Dukes of Hazzard, that dress that Lulu Hogg is wearing is a moo. Okay. Now, I specifically qualified my statement as words found in the English language. Okay. A moo is a Polynesian word, and it's not spelled like that. It is spelled like this. So the apostrophe breaks up the U's. So no, it is not a word commonly used in the English language that has two U's next to it. It is a Polynesian word. So I was correct. This is my point. All right, let's go back to something that's actually relevant. A factual justification continuum. All right, so if we draw a horizontal line here, we put 0 at one end and 100% at the other. What we're signifying here is how certain one has to be about whatever allegation it is that you're making. If we put in some other legal standards we're familiar with, beyond a reasonable doubt, proof beyond a reasonable doubt. This is the burden of proof, or I'm sorry, the standard of proof that we use to convict someone of a crime in America. We've got to prove it beyond a reasonable doubt. Now, it's not beyond all doubt. So it's not 100% certainty. There still could be some doubt, but the lingering doubt is unreasonable. So if you wanted to assign a percentage to that, I'd put it somewhere around 97, 98%. And this is just an exercise, by the way. You're not going to find this in some law school case book or horn book anywhere. This is just an exercise to help us maybe conceptualize something, this point a little bit better. Another very commonly used standard in our legal system is clear and convincing evidence. Don't see this in a criminal context very often. In some evidentiary hearings, you might see it, but it's used in civil cases. Some states use it in child custody hearings, child support hearings, spousal support hearings. Clear and convincing evidence. It's somewhere right around 75 or 80% of degree of certainty. It's a relatively high standard. Now, one very technical standard, and we mentioned this earlier, is preponderance of the evidence. By definition, preponderance of evidence, it literally means more likely than not. And therefore, if we were using whole numbers, we would put this at 51%. At its lowest level, preponderance of the evidence is 51%. And this is used, as most of you know, as the standard in civil trials. If someone is suing you, maybe you were in an accident and they're alleging you were negligent in causing the accident. The plaintiff, the person suing you, would have to prove by a preponderance of the evidence. It's more likely than not that you were being negligent, and therefore they win the case. But we're only talking about money, usually in civil cases, so it's not a high standard at all. Probable cause. If we wanted to put probable cause on this continuum somewhere at its lowest end, at its lowest level, I'd put it right below 50-50. Right below 50-50 at its lowest. Like it's bare minimum to say you have probable cause. In some cases, it could be slightly less likely than not. Now, that doesn't mean that we routinely arrest people on flips of the coin. Okay, we seek search warrants where we're 50-50 certain that there's narcotics inside the home or stolen property. But at its lowest level, it could fall somewhere down there. And obviously, reasonable suspicion is a much lower standard than probable cause. I'd put it somewhere around 25 to 30% certain what it is you're alleging. Now, as far as probable cause, the Supreme Court has said this many times. Here's a quote right here from the DC Circuit just from a couple of years ago. It is less than a preponderance of the evidence. There's no question about it. Probable cause is less than a preponderance of the evidence. So therefore, it's less than 51%. In some cases, it could be less than 50%. This is another. This is the Supreme Court talking about the same thing. It being less than proof of wrongdoing by a preponderance. Let me give you a couple of examples. A couple of examples of where probable cause could be actually less than 50-50. But other cases, we may need more than 50% certainty to say that we have probable cause. For example, let's look at this example here. All right, we got 3 men committed an armed robbery. The victim is shot during the robbery. Only one of the robbers displayed a weapon and used a weapon. We get a search warrant to search each of the residences of the 3 suspects. So they all have their own residence. We figure out who they are. We get a search warrant to search each one of the residences. We're looking for one gun. Obviously, the likelihood of it being in any one of the houses is 33.33%. But I can guarantee you that search warrant is going to be issued. Okay, we know that we have a good reason to believe, probable cause, that this gun is in one of 3 houses. We're not any more certain that it's in either one of them. This is clearly less than 50% probability as to each individual home. But this is a search warrant that would be issued. A significant fact here is obviously the seriousness of the offense. We have a robbery in which someone has died. So this is the law enforcement interest in collecting this evidence is significantly high. Now compare it to this. Okay, let's say we have a vehicle parked on the side of the street. It's unoccupied. We walk by the vehicle, peer inside. You see several white pills inside the center console area. Without getting closer to the pill, you can't tell whether this is an illegal substance or it's aspirin. Okay, or some other substance you're allowed to have. You need to pick it up to be able to see the markings on it or get a closer look at it. From outside the car, it could be an illegal substance or it could be a lawful substance. At best, we're 50-50, okay, as to what this is. That's not going to be enough to get a search warrant to search that car or to invoke the Carroll Doctrine. Either way, probable cause is probable cause. We would need some additional factors, or at least a factor, to tip the scale one way or another as to whether that's illegal or not. So something that's purely ambiguous, it could be unlawful, is going to require more, at least some factor to tip the scale beyond that 50-50. So this is consistent with the notion that probable cause, it's a flexible standard. It can vary depending on what it is we're trying to prove or show. Sources of information. This is a really important topic here. Where do we get our probable cause from? Now, we need to distinguish between evidence that is admissible in court as a rule of evidence. So in a trial, there's lots of evidence that we typically can't use in a trial because it would be in one way or another violate some rule of evidence. However, these formal rules of evidence that we use in trial, they typically don't matter for PC purposes. So, for example, you'll see what I mean now. Lie detector test, or I'm sorry, polygraph test. A polygraph test. Generally, most states, as a rule of evidence, a polygraph result is not admissible in a trial to prove whether someone is guilty or innocent. However, for probable cause purposes, a polygraph absolutely can be used as a factor in determining whether we've got probable cause to arrest someone or obtain a search warrant for a particular location. So whether the evidence itself that we rely on for our PC is admissible by itself is irrelevant. As long as it's reasonably reliable. That doesn't mean all polygraph results are going to be reliable. It's going to be depending on the qualifications of the polygrapher and everybody else who was involved. lineups. We're not going to get into detail about the constitutional requirements for lineups, but a lineup, whether it's a physical lineup like this or a photo array that we use, they can't be unduly suggestive. We can't put something about the guy that we think is the suspect. We can't have something in there that suggests to the witness that, hey, this is the guy we think we did it, like putting a suspect sign on. This would be an unduly suggestive lineup. If the witness were to pick the guy out with the suspect sign and identify him in court as the offender, that would be inadmissible in every court across the country. But even though the identification procedure might not be admissible in a trial, it absolutely can be used for probable cause purposes, depending on how reliable that process is. In a lot of states, preliminary breath tests, your roadside breathalyzers or whatever manufacturer used, most states, that's not admissible in a prosecution for drunk driving. Some states it is, but most states it's not. However, it can absolutely, PBT, preliminary breath test, absolutely can be used for your probable cause determination, even though the result might not be admissible in the prosecution. Criminal records, criminal histories, generally not admissible when we're trying to prove someone's guilty of a crime. But we do this all the time. We rely on people's criminal record all the time as a PC factor or an RS factor. So absolutely, that can be used as well. A big one, Miranda warnings. Violating the Miranda rule, failing to give a Miranda warning during a custodial interrogation, that's going to cause that statement to be inadmissible at the trial, but it could still be used for PC purposes. So even though we've violated the Miranda rule in some way, maybe we didn't read the warning when we should have, maybe they invoked their right to silence, but we continued to question them anyway. As long as there was no coercion to get that statement, we didn't, threaten them, make promises and things like that. Even though it would, as long as the statement was voluntary in the constitutional sense of the word, it could still be used as PC evidence or PC factor. So Miranda violation by itself will not cause the statement to be unusable for PC purposes. A big one is hearsay. A big one's hearsay. We're all taught that you can't testify to hearsay in court, which is true. There's exceptions to it, but for the most part, yes, hearsay information cannot be used as substantive evidence of someone's guilt. But we use hearsay information all the time in probable cause and reasonable suspicion determinations. So the Supreme Court goes all the way back to the mid-50s. They were talking about that the fact that we used an informer to get our PC information doesn't, which means it's hearsay, doesn't mean we can't use it. Now, when it comes to hearsay evidence from other people, we need to be mindful of a few things. Okay, we can't just believe everything. I'm sorry, Linnea asks, how are you drawing the line between PC and admissible evidence? So I'm assuming you mean admissible evidence in we're at a trial and we're trying to present this evidence as proof that they're guilty of the crime. Those the admissibility of evidence in that regard are governed by your state's rules of evidence. Every state has rules, and most of them are very similar. There are rules about the types of evidence that you can admit in a trial. Like, you generally can't admit hearsay. I, as the police officer, I can't testify on the stand as to what the victim told me in an effort to prove the defendant committed the crime. The victim has to testify. But that hearsay evidence can be used for probable cause purposes to get a search warrant, to search a home, to determine whether I have enough to arrest the person. So all of the things that I just mentioned, typically polygraph results are not admissible as evidence of guilt or innocence, but they can be, and that's because of rules of evidence. The state has, they're written down. They have written rules of evidence about what kind of evidence is admissible. It goes to the reliability of the evidence. It boils down to how reliable it is. But my point is that those rules of evidence, those formal rules of evidence that we use in trials, they're not applicable in the reasonable suspicion probable cause determination. As long as the evidence that we're relying on is reasonably reliable, reasonably trustworthy for this limited purpose, of searching and seizing, the rules of evidence don't apply. But it still has to be somewhat reliable. My point is, you still have to have some degree of reliability when we're evaluating this evidence. When it comes to hearsay information, this is the most frequently relied upon type of evidence we use for PC purposes. We use hearsay, stuff other people tell us. There are two things that we generally need to consider before we act on the information, before we add it to our probable cause basket. We need to ask, one, how credible is the source of the information? The person who's given us information, how credible or how trustworthy are they? And the second thing we need to ask and determine is, how does that person know what they're telling us? Okay, what's their source? Are they relying on their own firsthand knowledge? Do they see it themselves? Or are they relying on what someone else told them? Because that's a layer of hearsay. Okay, obviously, firsthand knowledge from that source is more reliable than hearsay from them. So, how trustworthy is the person, and how do they know what they know? What is their basis for knowledge? As far as trustworthiness goes, if this woman walked up to us and said, "Hey, make some statement, just tells us something, whatever it is," it would be reasonable to believe she's telling us the truth. Now, we're going to make some assumptions here. Okay, it's not Halloween, so it's not someone dressed up like a nun, and I have no reason to believe it's not a nun. Okay, my point is, this type, she's an inherently believable person. It would not be unreasonable to think whatever she's saying is truthful. Versus, what if this guy came up to you and made some statement of fact? Okay, would we have a known reason to at least question whether he's being trustworthy today? Now, this first requires you to know who this is. Does anybody know who this is? Trevor obviously has an idea who this person is. This is an actual well-known public figure. Does anybody know who he is or what he does? More people know maybe what he does, might not know his name. Or I should say did. He's retired now. Yeah, he's a reporter. It's not Tom Brokaw, but close. Same company. Brian Williams. And what is Brian Williams most notable for today? He's noteworthy for he's a proven liar. Yeah, yes, Sean, he's a proven liar. He reported about an incident when he was embedded with an army unit, I believe in Afghanistan. Talked about being in a helicopter, taking a bunch of enemy fire, a very harrowing experience. Comes to find, he filed a report with all this information. Turns out when people went back and did a little follow-up and interviewed the soldiers with him, they said, yeah, he was with us. Him and Hillary was there too, Sean. He was with us, but that didn't happen. We didn't take enemy fire. It was just a routine mission. When he was finally questioned about it, he or called to the carpet, he admitted he made it up. At that time, when it came to light that he lied, he was the anchor of NBC Nightly News. He was promptly fired from NBC Nightly News because we can't have the guy on the 6:30 news giving us the news who's now a proven liar. So they fired him from the news desk. They didn't fire him from NBC completely. They gave him a little time off, brought him back. Not CNN. They brought him back to MSNBC, Michael, the minor leagues of NBC. So he came back to MSNBC, same thing as CNN, but he did spend another, I don't know, 12, 15 years there and recently retired. But the point is, he's a proven liar. And now that everyone knows who he is, would we all agree that if he makes some allegation to us today, it would be unreasonable to just believe him on his face. So when we have someone like that when our informant's credibility is questioned, or at least questionable, or we can't figure out whether they're trustworthy or not, then we typically have to do a third thing. How reliable is the information he's providing today? And that's usually going to require some corroboration. We're going to have to can we corroborate his statement, or has his statement been made against what's called his penal interest, meaning is he implicating himself in criminal activity? A lot of times courts consider that kind of information to be reliable. If you're basically confessing that you committed a crime, then we're presuming that you're being truthful about what you're stating in this particular case. But we can't just believe it. As far as basis for knowledge, so we need to know how trustworthy is our source and what is their basis for knowledge? Are they relaying firsthand knowledge that they have, which is more reliable than hearsay information? So we would need to ask questions and figure these things out. Now, as far as different categories of people, other police officers are presumed to be trustworthy. So if another officer gives you information, you're allowed to believe that officer is telling you the truth without any kind of corroboration, unless you have some reason to believe that officer is lying to you. Now, we still need to establish that officer's basis for knowledge. How do you know what you're telling us? Another category, we frequently rely on these folks, are, yes, the collective knowledge doctrine comes into play here with the other police officers. It's not quite the same thing, but it's very similar. What the collective knowledge doctrine, Michael, is when we're presumed to know the information that officers in our work group have. So if one officer in your group of officers doing an investigation has probable cause to search a car, for example, everyone in that group is presumed to have that same knowledge under the collective knowledge doctrine. So there's a lot of overlap between collective knowledge and the reliability of another officer. Citizen informers is another category. These are just your everyday people who are identifiable, who call the police and make some kind of allegation. Courts say consistently a citizen informer is presumed to be reliable. This is someone who's just volunteering information. They call the police, they approach a police officer, they want nothing in return, they don't want money, they're not trying to work off a charge, a previous charge. They're just doing their civic duty, reporting information to the police. I'm going to skip this scenario with TJ Hooker just for time purposes. We're already at 10 o'clock, or we're already at 10 o'clock where I am out in Virginia. But I'm going to skip our scenario. But to get to the point that citizen informers, they're presumed to speak honestly and accurately. So absent a Brian Williams type, where we have a reason to question his truthfulness, if we don't know the person, we've never met them before, we are allowed to believe they are telling us the truth about what it is that they're alleging. Well, we're allowed to believe they're not lying. Now, whether they're being truthful or not, that's yet to be determined, but we're allowed to believe they're not lying to us. So that goes a long way in developing our probable cause. Now, we still have to confirm how they know what they know, but we don't have to typically corroborate their information once they give us a sufficient basis for knowledge. They're presumed to speak honestly. Confidential informants, these are people that we know who they are, but we're not going to have them testify or identify themselves in court for various reasons. Here, we're going to need track records. Okay, we're going to need to do something to corroborate their information, because we're not going to put them on the stand and test their truthfulness in court. So we typically have to establish a track record dealing with confidential informants. In this case, the McRae case, the fact that this informant testified or provided information in the past 15 to 16 times that led to the discovery of narcotics or resulted in arrests, that's showing that he has a track record of providing reliable information. So that means today, the information he provides us today, we would be allowed to believe he's being truthful in this regard today as well. Some things that we typically do to establish track records of our confidential informants, the people who we don't want to put forth to testify. Have they provided us information in the past that led to convictions? Obviously, convictions are better than arrests, because with the conviction, we've proven that they've committed the offense. Although an arrest, information about providing information leading to arrests can still be very valuable in our track record determination. Has their information in the past led to the discovery of evidence or contraband? Have we been able to verify predicted criminal activity that they have alleged? All of these things would go towards establishing their track record. The informer's privilege, the reason we don't have to identify our confidential informants typically is something called the informer's privilege. This is kind of a side point, but officers a lot of times ask, do we have to identify our informant? No, there's this common law privilege called the informer's privilege that goes back hundreds of years. It's really not the informer's privilege. It's really the police's privilege to not have to identify our sources. So typically, if we use a confidential informant for information that leads to the development of probable cause or reasonable suspicion, we don't have to identify that person because there's this need to use informers for law enforcement investigations. That's the reason we have this informer's privilege, because they perform a vital part in law enforcement. Here's some of the reasons, and these should make sense to you, why courts don't require confidential informants to have to identify themselves, or for us to have to divulge their identity. It encourages people to cooperate with the police. It protects them from threats to harm themselves, their family. Preclude these adverse social reactions, being called a snitch and those kinds of things, and also protects from claims of defamation and malicious prosecution. There are some cases, though. The McRae case, it does not violate the 14th Amendment or the 6th Amendment Confrontation Clause to keep informants confidential. Before the McRae case, there was some debate about whether it would violate the constitutional rights of a defendant to not know who the informer is, and the Supreme Court says nope, it does not violate the 14th Amendment, nor does it violate the Confrontation Clause of the 6th Amendment. So yeah, in a preliminary hearing, because that's what we're not usually using informants to prove someone committed a crime. We're using informants to collect evidence, and we use the evidence to prove they committed the crime. So we're using informants usually for probable cause purposes, not for proof beyond a reasonable doubt. James says in Virginia, there's a law that takes that away. Well, yeah, there are circumstances where he's talking about taking the informer privilege away. There are circumstances where we may have to disclose the identity of the informer. I don't remember. I don't have them listed here, but yes, if the defense can show that without knowing the identity of the informant, it would somehow prejudice their case. They could not put on a viable defense without knowing who this informer is, then the judge can require the prosecutor to disclose the identity of the informer. Now, typically, that disclosure doesn't occur in open court. It occurs in what's in camera, which is in the judge's chambers. So the prosecutor, the defense sit before the judge in the judge's chambers. The prosecution discloses the identity of the informer, and then the defense attorney asks the questions that he or she needs to know to try to evaluate the reliableness of the informer. So yes, so there are certain circumstances when we do have to disclose that, but ultimately it's the judge's decision as to whether that has to be disclosed. So, and different states do have different rules of evidence regarding how extensive the informer's privilege is, but all of them do recognize it to some degree. Let's see, in Ohio, they've got to commit. Okay, informant has helped set a commission crime, and if the informant is a witness to the crime, or if they're vital to establish obviously, Zaki, absolutely. If we're trying to use the informer to prove an element of the offense, there's no question about it. Under the 6th Amendment, that the defense has a right to confront that person because they're providing evidence against them. But where we rely on the informer privilege is not when we're using the informer's information in the case in chief. We're using it in the preliminary stages to develop PC to collect evidence or to develop probable cause to make an arrest. So that's where they're privileged. But yeah, if we need them to prove an element of the crime, their identity is going to have to be disclosed, or we're going to have to dismiss the case. Anonymous informants, we're not going to dig too deeply in these. Obviously, they're of limited value for probable cause purposes. They're more valuable in reasonable suspicion purpose cases, but that's not to say information from an anonymous informant can never be used for PC purposes. The Illinois versus Gates is a very famous case that involved an anonymous letter sent to the police, where that anonymous letter formed a substantial basis for the probable cause to obtain a search warrant to search the Gates's home for evidence of narcotics trafficking. Now, there was a significant degree of corroboration that the police did along the way, but the information contained in this truly anonymous letter was a substantial factor in determining there was probable cause to search this home and also to search the vehicle. So it's not to say that anonymous informants are completely useless, but it's very hard because one, it's hard to establish the trustworthiness of someone we don't know who they are. And in a lot of cases, it's very difficult to determine what their basis for knowledge is, how they know it is what they're alleging. Now, in this case, you could infer by some of the statements that the informant made in the letter that this is clearly a person who has some kind of inside knowledge about what the Gateses were up to in this case. So it's an interesting case, interesting read. If you want to learn a little bit more about how we can use anonymous tips in PC purposes, for PC purposes. In Alabama versus White, it's a reasonable suspicion case, but this is a case where the court said an anonymous tip, coupled with a slight degree of corroboration, in this case by the police, did amount to reasonable suspicion to stop her vehicle. Although they said it was a close case, so it's good to read Gates, White, and White together. Read the two of them together and see what Gates was or White was lacking that Gates actually had, to kind of compare the two. Now, Gates is a PC case. White is a reasonable suspicion case. All right, again, yeah, it was a close case, but at the end of the day, the court upheld the stop significantly based upon the tip. And the tip had what was called predictive information. And there was predictive information in the Gates case too. You'll notice that with anonymous tips, if they can provide information predicting what the person is going to do, and then we confirm that they actually did that, that's how we can test the reliability of an anonymous informant.